Lord, my ladies and my lords, I'm sorry to interrupt the Solicitor General. We have a small application to make which will not take more than 2 minutes because it's a straightforward housekeeping issue. And we got served last night.
What is it, Senior Professor Kindiki?
I'll allow Mr. Muthomi to address the court for 3 minutes or less.
Thank you, Your Lordship and my ladies. We want to make an application in respect to 2 affidavits that we would like them to be struck out of the record. Now, via our notice of motion dated 8th of June 2021, we filed an application under Rule 29 of the Court of Appeal Rules, seeking to adduce further evidence in form of the JLAC report. That application was allowed on 25th of June 2021, and the court in its ruling indicated that any party who wishes to respond to our affidavit to do so by close of business yesterday. We have received 2 affidavits, one by IBC, sworn by Michael Goa, and another one by BBI Secretariat, sworn by Dennis Waweru on 27th of June 2021.
Yes.
Now, the said affidavits seemingly are in response to our affidavit adducing the JLAC report, but a close look at the said affidavit speaks otherwise. I will begin with the affidavit by IBC, where IBC seeks to introduce new evidence that has nothing to do with the JLAC report. What they're seeking to adduce is a Gazette notice dated 16th September 2020, confirming that there has been an ongoing voter registration. Now, this is an issue that was brought up at the High Court. IBC did not respond to that issue by adducing that Gazette notice. I note the Gazette notice is dated 16th of September 2020, so there was nothing that prevented them from adducing that piece of evidence at the High Court. It would then appear that they are trying to cure defects in their response at the High Court by sneaking in this piece of evidence at this juncture. My view is that they ought to have sought leave, just like the way we did, to adduce that Gazette notice.
When was that affidavit filed?
That affidavit was filed yesterday, my lord, and it's dated 28th of June.
Did it comply with the times?
Yes, it complied with the timelines that the court had issued in respect to the response to affidavits, but our contention is that it does not respond to the JLAC report. It seeks to sneak in evidence that was not availed at the High Court. So in that respect, I'll be asking the court to expunge or strike out paragraph 5 and 6 of that affidavit, together with the Gazette notice that has been annexed thereof.
Not the entire affidavit, just paragraphs 5, 6 and the Gazette notice?
Correct, my lord.
I'm not sure whether we have even seen the affidavit.
Perhaps the court can take time, and it is dated 28th of June 2021. I believe it was filed yesterday by IBC. It is important for the court to look at those specific paragraphs before making a ruling on the same.
That's all?
Yes, in respect to the other affidavit sold by Dennis Waweru, it is a 1-paragraph affidavit. It seeks to introduce a JLAC report on the referendum bill of 2020, Now, this is a bill that is distinct and separate from the BBI Constitutional Amendment Bill. It would then appear that this part of bill is being introduced to cover gaps in respect of the lack of legal framework in the processing of a constitutional amendment bill by way of a popular initiative. Again, it does not even seek to respond to the affidavit of Merodu Waweru on the JLAC report. It is just a new piece of evidence that is being introduced at this juncture. Again, it does not comply with Rule 29 of the Court of Appeal rules. It is purely being brought again to improve their case. I note that the referendum bill that is being sought to be introduced, rather the report, is dated October 2020. Again, there was no reason as to why the BBI team could not have adduced this piece of evidence at the High Court. This, in our view, my lords and my ladies, amounts to trial by ambush, and it's a way of sneaking in evidence at the Court of Appeal and procedurally. That's all, my lord and my ladies. Thank you.
So can IEBC and BBI Secretariat just respond quickly?
If it may please, my lords and ladies, the response is really very simple. First of all, the responses were filed within time. Secondly, to the extent that the applicant on this issue sought and was allowed to adduce new evidence, it is not in their province to determine how the respondent should respond to that new evidence. The question of relevance is for the respondent to that issue, not for them as the applicant. More importantly, my lords, as indicated, they sought to introduce a report that was not before the trial court, the Justice and Legal Affairs Committee report. And as demonstrated, they did not produce the complete report. That report refers to an annexure, which is an additional report of the JLAC committee dealing with the referendum bill. That is the only report that is now produced in response to complete the new evidence that they have brought before this court. They cannot say it could have been produced before the High Court because they had not produced the JLAC report in order to complete it. Most obliged, my lords.
My lords and my ladies, on behalf of the IBC, first we want to associate ourselves with...
Sorry, this is for record purposes, Mr.
My name is Gumbo Eric.
Okay. Yes.
So my lords and my ladies, first I would want to associate myself with submissions from learned senior counsel, Mr. Otiende. Secondly, I would want to point out that the issue of the annexure that is in our affidavit first is a gazette notice, which ordinarily would be a public document. Two, that in addition to that, the JLAC report that was filed with the leave of the court, and we did mention this in our replying affidavit, introduced a number of new issues. We didn't want to come and make that application again, that we respond to those new issues, which then would have had the effect of delaying these proceedings. The singular issue that Gazette notice responds to is just a confirmation of the fact that there's been indeed continuous registration of voters and nothing more. My lords and my ladies, if you look at the JLAC report itself and the Hansard that is with it, the deliberations that have been presented before you are of such a broad nature as to cover each and every aspect of the petition that is before you. In the event that we don't have that evidence or that gazette notice for purposes of responding to those issues, my lords and my ladies, we shall stand prejudiced. It is not introducing anything new. The question of continuous registration of voters has been before you. There's nothing new that has been introduced. That will be all, my lords and ladies.
Sorry, Council, can you connect the issue of the JLAC report and the continuous registration of voters? Let's get that connection clearly.
Yes, my lord. So what I indicated is that other than the JLAC report itself, we also had the Hansard, which was part of the document that were introduced with the leave of this court. The deliberations that went on, both which are contained in the JLAC report, as well as in the deliberations, are such as to cover every single spectrum that this petition is dealing with. So, to that extent, if we do not get an opportunity to respond to some of those deliberations, which would be available to the respondents for purposes of the proceedings that will be before you, then we'll stand prejudiced because we'll not have had an opportunity. And I said, my lords and my ladies, in our replying affidavit, we did mention that that was the risk that that leave was going to then place us in, because it was going to introduce issues which we thought we would not have had an opportunity to deal with. One of them is that question of registration of voters, because it is an issue that also was touched on if you look at the Hansard that was that supported the report.
Okay.
I'm most obliged.
In a brief rejoinder, my lord,
I would request, for purposes of recording, whenever counsel you stand there, just say your name, even if it is for the 10th time, because the transcription needs to record that.
Much obliged, my lord. My name is Elias Muthomi for the 19th, 20th, and 21st respondents in Appeal 291. In a brief rejoinder, my lord, in respect to my learned senior counsel, Otiende Amollo, the affidavit does not in any way state that they are seeking to introduce an annexure to the report that we had sought and was granted leave to adduce. In fact, the title of that document in itself does not even say that it is a replying affidavit. The title is that it is the appellant's further affidavit. If indeed that referendum bill was part of the JLAC report, there was nothing that would have been simple than for them to state exactly that. We confirm that we filed a full report as received from Parliament, and the same is complete. As to the issue raised by the IBC, the court in its ruling was very clear, granting us leave, that the respondents were only supposed to respond to issues related to the production of the documents stated in our application, that is the JLAC report. Now, the Gazette notice that is sought to be introduced has nothing to do with the JLAC report. It was not an issue that was discussed by Parliament. It is not captured in the JLAC report. We do not even intend to address the issue of voter registration through the JLAC report. What is important, my lord and my ladies, is that the issue of voter registration was one of the issues that was active in the High Court. It is an issue that the High Court made a determination on. It was part of the pleadings by the petitioners. IBC had that opportunity to respond to that issue at the High Court, because again the Gazette notice being sought to be introduced is not a new Gazette notice. It is dated 16th of September 2020. Now, these petitions were filed in December last year, so this Gazette notice was in existence before those petitions were filed. They ought to have introduced that piece of evidence at that time. That's all, my Lord. Thank you.
My Lord the Mayor, on behalf of the 76th respondent.
To respond to the same.
Yes, my Lord, and the reason I've been constrained to get on my feet.
This is Mr. Foreko, Mr. Muthomi.
My name is Muthomi Nkolu, my Lord. And on behalf of the 76th respondent, who is Moraro Moke. My Lord, I would not ordinarily have stood, but the reason I'm constrained to come here is because this issue of voter registration was raised in the petition that Mr. Moraro Moke filed at the High Court. As you make your decision on whether the IBC should be allowed to introduce a Gazette notice showing that there has been continuous registration all along, my Lord, I will invite you to look at paragraph 769 of the judgment of the High Court. And the reason this is important, my Lord, in the High Court, the official position of the IBC, according to that paragraph of the judgment, was that the last time the continuous voter registration was done was just before the by-election for Kibra constituency in the year 2018, about 3 years ago, my Lord. And now they are coming before you, having told the High Court that, to tell you, actually, we have been doing voter registration all along, and we have a Gazette notice to show it. A Gazette notice that was in existence at a time when they told the High Court a very different position. My Lord, we are asking you to note that. It's on the record. And for that reason, we will very humbly urge the Honorable Court to strike out that Gazette notice. They are trying to close the stable long after the horse has bolted. Thank you, my lord.
Now, the view of the court is that we want to give a short ruling at 11:30 when we return from our tea break. I do not know whether the issue relating to that affidavit and the Gazette notice is one that is going to feature in Mr. Ogeto's address of the appeal. I don't think it is. It will come later. And if the issue will come later, we will then want to rule on it after we adjourn at 11.
Lords, to be of assistance to the court, this is not a matter that is featuring in our submissions, and we can proceed as proposed by your lordships and your lordships.
So just 1 minute.